Good morning, everybody. I'm Chuck Williams, CEO and co-founder of Finspire, and we are a corporate retirement plan investment advisory and consulting firm based in Schaumburg, Illinois. And today is the latest in a series of discussions we've been leading, whereby we bring in industry experts to discuss topics that are particularly relevant for corporate retirement plan sponsors. Perhaps no issue has been of greater interest recently among institutions and individuals than cybersecurity. So our discussion today will last about 45 to 50 minutes. All participants are on mute. If you have questions, we encourage you to ask those in the chat box, and we'll attempt to address those throughout the discussion. In the event we're not able to get to all of the questions, happy to follow up with you afterwards to make sure your questions get answered. So today's discussion, we're going to be going through a variety of topics. I'll be moderating this discussion today. The information provided is educational only, not to be considered legal, accounting, investment, or tax advice. Please consult with appropriate counsel before implementing any strategies discussed during our discussion. So I'm very excited to be moderating this discussion today, whereby we'll have two very accomplished attorneys with knowledge, expertise, and experience in the areas of cybersecurity and ERISA corporate retirement plans. Rick Pearl and Cristin Obsitnik are both partners at Faegre, Biddle, and Reath. Cristin's practice focuses on advising employer plan sponsors and service providers in design and administration of retirement plans and health and welfare plans, and routinely counsels plan sponsors and committees on fiduciary governance matters. Cristin also has extensive experience in advising clients in corporate transactions with respect to benefits and executive compensation matters. Rick is a trial lawyer who represents plan sponsors, boards of directors, committees, shareholders, and service providers in complex ERISA matters, including 401k and 403b litigation. Rick has earned national recognition for his thought leadership and has extensive knowledge of ERISA legislative history and current issues. As I mentioned, myself, CEO, co-founder of Finspire, I'm a lead advisor on corporate retirement plans with specializations in investment management, plan design optimization, executive benefit plans, and overall plan governance. So we'll focus on today is these three areas: ERISA cybersecurity, history with retirement plans, what's new, what's the impact, and actionable steps to protect your company and your employees. So to start out with, I have a quick question for Cristin. If you can just give us to get the ball rolling, provide some insight on what the general problem or concern is that ERISA plans might need to address.
Sure, Chuck. Thank you. Well, ERISA in general imposes the fiduciary requirements on plan sponsors and committees that oversee retirement plans. And so the last 5 years or so, there's been the growing threat of the cyber theft, which includes the identity theft, and 401k plans are prime targets for those bad actors, we'll call them, because of the large amount of assets that are in those plans. And so that leads to, as a plan fiduciary, the question becomes, what is your responsibility to protect these assets from these cyber threats? And we've seen many examples, our clients contact us. Unfortunately, it's becoming more often where they have a participant's information is stolen. The imposter will submit a transfer request to the record keeper for a distribution, and in some cases they'll request a callback to confirm information. And in one case, our clients somehow they even intercepted the phone number, and so they were able to get the phone call to answer those questions. And then as a result, hundreds of thousands of dollars can be out of your account when you log in the next time to see. So because of this, the committees need to start focusing on what is their responsibility for this. And the DOL has taken notice as well, and they're increasingly becoming involved with the cybersecurity, and which is leading us as advisors at these committees to see that eventually this is that these committees do have some responsibility with these plan assets, and it's kind of foreshadowing that the DOL maybe will start some enforcement initiatives in this area. And recently we've seen it come up. We had a DOL audit where it was essentially almost complete, and at the kind of right at the tail end, the DOL sent a list of 36 questions related to cybersecurity for the plan sponsor to answer. We think it was more information gathering to see where plans are at, but to us, it's clear that they may be taking it a step further in the future. And we've also seen the issue come up in transactions as well, where in the reps and warranties, sellers are being asked to rep that they have the appropriate cybersecurity practices in place for their benefit plans. And Chuck, this is something you and I talked about as well, where retirement plan auditors are going to start addressing this in their annual plan audits.
Yep. Thank you very much, Cristin. Yeah, that we've definitely seen that with audits, both DOL and independent auditors. And as Cristin mentioned, a great point as during transactions, companies themselves, part of the due diligence is becoming a bigger topic. So Rick, historically, what were the legal requirements under ERISA with respect to cybersecurity?
So generally, the duties that ERISA imposes on plans, it wasn't very clear. So ERISA regulates benefit plans in two principal ways. One is with fairly objective standards, non-fiduciary type standards. So things like the requirement that plans provide documents and maintain documents, file reports, certain express prohibitions or requirements on distributions, things like that. And then ERISA also regulates conduct of people who ERISA designates as fiduciaries. But ERISA itself does not have any provisions regulating cybersecurity issues. The situations that Cristin mentioned above, one of them was the subject of a lawsuit that was dismissed just earlier this year that alleged that fiduciaries of a plan breach their ERISA fiduciary duties. So these general duties that people may have heard about of, prudence and loyalty, that they breach those duties and not attending to cybersecurity issues. The allegations in that case related more to, this very general sort of hiring of a service provider, failing to address cybersecurity and the retention of a service provider, but the way that the plaintiffs in that case tried to incorporate cybersecurity requirements through ERISA was through that general standard of prudence.
Great. So obviously there have been some changes though recently. So with the new DOL guidance, maybe you can give us a little overview of the new materials issued by the DOL on cybersecurity and how these impact our clients.
Sure. So in April of this year, the Department of Labor issued these 3 publications on cybersecurity practices and cybersecurity issues. And generally, here's what they are. So the principal one I think that plans are concerned with, plans and plan fiduciaries are concerned with, are these hiring tips, these tips for hiring a service provider. So these were directed at the plans and the fiduciaries of the plans to help them fulfill what the DOL sees as the fiduciary obligation of prudence under ERISA with respect to cyber practices. So again, ERISA just has this very general requirement that people who are characterized, or entities that are characterized as fiduciaries, have to act prudently and loyally. Well, what does that mean? The DOL in these guidance pieces provided its opinion on what the standard of prudence is or might be for planned fiduciaries with respect to cyber issues. You also have the service provider best practices. So this was a very technical piece that was directed at service providers, and that provides these tips on securing systems and information. And the third piece was directed at plan participants. This document provided some tips generally on securing accounts and their information.
Great, thanks, Rick. And let's go to each one of these individually. Start with the first piece of guidance. It's likely the most relevant for our audience today. Tips plan sponsors should consider when hiring and monitoring retirement plan providers. Rick, can you unpack these pieces, this guidance for us, and what do the hiring tips say?
Sure. So the DOL's position is that the plan and plan fiduciaries have to take the lead on securing both their internal systems and requiring plan service providers to implement cybersecurity practices. So the hiring tips suggest some fairly significant measures of due diligence and contract terms that plans have to engage in and plans have to require or should require when they enter into agreements with service providers.
Great. And what due diligence specifically does DOL recommend companies do?
There are these two general areas of due diligence. The principal area is requesting certain information from the service providers. And then the secondary area, some investigation that plans will conduct on their own into the service provider's history. So generally what the DOL wants plans to do is to request the service provider's cybersecurity practices, their security standards, confidentiality standards, and other information, and compare that to industry standards with respect to those issues. Also, the DOL wants plans to request audit reports, audits of the service providers using these recognized cybersecurity standards as a basis for the audit. And then the DOL is also recommending that plans investigate service providers' track records, as they call it, the past security incidents, litigation history, losses involving cybersecurity issues, and also request insurance information from service providers for insurance that will cover cybersecurity risks, both internal risks, so employee theft, and external risks like the hacking, the identity theft type situations.
Great. And you mentioned here on the slide the contract terms with service providers. Is there specific contract terms that DOL recommends?
Yeah, so all of these issues that I just talked about, these cybersecurity areas of due diligence and investigation, in addition to some other areas, the DOL wants plans to address these areas in their agreements with service providers. So the DOL suggests that plans draft these new terms into engagement letters that address things like security protocols, confidentiality of participant information, notifications if there's a cyber breach, ongoing auditing requirements and the obligation to share information with the plans, record retention and destruction, and insurance for cyber risks. The DOL also issued a warning, I would call it, against plans agreeing to limitations of liability or indemnification, could function similarly with service providers with respect to cybersecurity incidents. And that's sort of an interesting point by the Department of Labor, because typically they haven't waded into the area of private contracts, but they are suggesting that plans look closely at any limitations on service provider liability for cyber breaches at the service provider. Great.
Thank you. Yeah, and we've just seen it on our end where contract terms, frankly, with a record keeper and TPA aren't often reviewed from their initially set up, and these contracts were in place before these cybersecurity issues, really became front and center. So I know there's a lot of effort reviewing those, and both the providers are updating their contracts, and plan sponsors are looking at those closer than they have before.
Chuck, are you drafting some as a service provider? Are you receiving proposed terms as a service provider, sort of both? How are you dealing with that?
Yeah, so we, as an advisor, we are drafting just terms of ours. We are, as an advisor, typically we are not touching plan participant data, but that is something that we are drafting as well with our firm. Thanks. So if we then jump to service providers best practice. So first is what the plan sponsor should do for evaluating and monitoring. The second one is, the DOL came out with these specific 12 tips that they talked about, and asking service providers, again, primarily record keepers and third-party administrators, what they should be doing. So, what do these best practices say specifically, and can you explain generally what the technical suggestions are to the service providers?
Right. So this is an interesting document. It's directed at record keepers and other service providers over whom the DOL generally does not have any enforcement authority over them, because in most instances they're just not fiduciaries. I think what the DOL was trying to do was to issue this document directed at them, but then require or suggest that the plans then use this document in assessing whether the service providers have compliant or secure cybersecurity practices. So it's a very, very technical document. It addresses a number of components to cybersecurity for the service providers. So everything from preparing and following a written cybersecurity program to training employees, audits, so annual audits of cybersecurity practices, establishing clear roles at the service provider for who's responsible for what aspects, control procedures, cloud data. The DOL is suggesting that service providers assess the security of data that's in the hands of their service providers, so cloud providers, things like that. Ongoing training, recovery of lost data, encryption of data, and responses to incidents. And again, this is a very, very technical document. It's quite frankly over my head with some of the technical requirements. But I think, again, the DOL's goal was really to not just inform service providers of some suggested good practices, but to kind of nudge the plans and say, take a look at that document, because when the plans then assess their service provider cybersecurity practices, that document provides some technical guidance as to what the plans should be looking for as well.
Great, thanks, Rick. And then from our perspective, obviously cybersecurity is not a new issue for service providers. They have been working on this, putting enormous amount of resources in this, for quite a while. And when we do our due diligence on the different service providers, we see that what they are spending and the amount of effort that's put into that. The DOL's recently just giving more specific guidance, and our initial discussion with the major service providers is we've been doing a lot of this all along. And now it is more just to document that for the benefit of the client, of their clients. So we are seeing more of this being formalized in addressing specifically each of those 12 issues and documenting that in responses as well as in agreements. So if we go on to the third part, is at the participant. You guys were participants, so what do the participant tips say? And this, Cristin, maybe more for you.
Right, yeah, so I mean, all that Rick talked about, the plan sponsors can do everything right and put everything in place, but I think the DOL recognizes that there is some responsibility on the participants, and they can put their own account at risk if they don't take certain steps. And so as part of these 3 tips that the DOL issued was a tip sheet for participants. And it kind of goes through the basic rules of how to keep your online information safe. And I think one of them is important in the sense of, it seems so basic, but to register and set up your online account. I mean, I think most people do that, but depending on your population of employees, some of the older participants feel, well, if they don't set up an online account, they're safe. And unfortunately, that's sort of what we know is the exact opposite. If you don't set up your online account, you're more at risk for the identity theft. And then sometimes you don't even find out that anything happened, until you receive a letter in the mail. And so that's, I think, one of the important tips. Some other things that just goes through how to have strong and unique passwords, multi-factor authentication, where they might have to contact you on your cell phone or different ways, steps before you get into your account, to keep your current contact, have current contact information. So if something does happen, they can get to you. The record keeper can contact you right away. And so it's there's 5 or 6 other tips, but it's written really well, plain English. I think that the DOL didn't say it should be distributed, but I think the format it was presented in, it is something that plan sponsors should consider distributing to their employees. I don't think employees are going to know to go to a DOL website and pull the tip sheet for themselves.
Mhm.
And it also can be kind of incorporated into if you have education sessions throughout the year on an individual basis, you can always mention it, or group sessions. The other way to kind of communicate this information could be through a company newsletter, just a short blurb, a reminder, a link to where you can get these tips. But again, like I said in the beginning, plan sponsor can do everything right, but participants do have some responsibility and to keep the information safe.
Yeah. Thanks, Cristin. Yeah, and I think it's also important for plan sponsors to understand what is the cybersecurity protocol of your provider. So not every company does two-factor authentication, as an example. Some of them will have some warranty saying, hey, if you do this and somebody does breach into it, we will, hold you harmless for that. So those are ever changing. And so really it's important that the plan sponsor understands what cybersecurity measures are available at the provider. And then, Cristin, to your point, also educating the employees and what tips are and how to protect their data. And that's a really good point. Also, when we're doing education meetings, we will have people who are not as comfortable putting what they deem to be putting their information online by signing up. The big risk is often if you don't sign up and put in a name and password, somebody else could do that for you, right? So education is obviously a big part of it. So great. So a question that comes up is, are this guidance legally binding on anyone? So Rick, if you want to maybe touch on that.
Yeah, it's an intriguing question. These are not regulations. So, just generally the way ERISA works is you have the statute itself, and the provisions in the statute are binding law. The DOL has authority under federal law and ERISA to issue regulations. And regulations have this comment period. They're published. They can be revised. Regulations are subject to court, challenge, court review, and validation. These aren't even, there's some sub-regulatory guidance that, maybe has more authority than other pieces, but these are non-binding expressions of the DOL's sort of position on fiduciary obligations to address cybersecurity. And two of the pieces, as I commented before, the service provider tips and the participant tips are directed at people over whom the DOL doesn't even have any authority. So the way, though, that non-binding guidance like this can become law, though, is through court action. And the way that would happen is, let's say there's a cybersecurity incident and a participant sues for a loss and says that the fiduciaries breached their fiduciary duty of prudence because they didn't ensure the cybersecurity of the plan or the service provider. The court might look to the DOL guidance and say, this is the standard of prudence that the court is going to impose on fiduciaries as a matter of law. It's a backdoor way for the Department of Labor to issue standards of conduct. And I'll sort of save I'm not going to save my opinions on it. I'm going to express my opinion. And I think that for something like this, without a comment period, and when you deal with cybersecurity where things are changing so quickly, a lot of these tips may become obsolete soon. Maybe that's a reason why the DOL didn't want to issue a regulation. But I think the point to be made is that generally under ERISA, the standard remains that of prudence. What would a prudent person in your circumstances do, considering your particular type of plan, your participant base, the assets, the way that participants use electronic devices, things like that. And these are generally tips. However, because the DOL's view is that this is what prudence requires, you should expect the DOL to take the position that ERISA requires this, and they can do that through audits, investigations, or even enforcement actions if they think that there's a lapse in cybersecurity practices.
Great, thank you. So if a court were to require fiduciaries to comply with this, is there a way to handicap liability on this? So if a client or somebody out there, plan sponsor, and their advisor on a $25 million 401k plan, they're going thinking, what is my liability on this? And I have 250 employees in this. Is there any way to get an idea what that would be?
Sure. So there are two general ERISA provisions. ERISA has this section that creates claims, authorizes certain remedies. The principal one is a provision that authorizes the recovery of losses to a plan or a plan account caused by a fiduciary breach. And that renders fiduciaries personally liable. So members of committees, members of boards of directors, service providers or investment managers, to the extent they're fiduciaries, would be responsible under this provision for actual losses to a plan account or multiple plan accounts. So if $200,000 is fraudulently transferred out of an account and a court determines that it was caused because of a cybersecurity lapse by fiduciaries, the court can order the fiduciaries to return that money, plus the interest, attorney's fees, and court costs. There's another provision in ERISA that authorizes a court to orders all types of equitable remedies, so injunctions, changes to plans, removing fiduciaries, requiring cybersecurity practices to change going forward. So there's also the ability of a participant, even in the absence of a loss, there's some court cases to suggest that a participant would have the right to bring a court case and require changes to be made at a company. So these are really the principal risks under ERISA.
Even in the event where there wasn't a loss. So just as information on participant data, I guess.
Yeah, and what the provision says is in the event of a breach of either ERISA or the terms of a plan, so there has to be some breach. There doesn't necessarily have to be a loss of money, but like you said, if let's say there's a hacking incident, they manage to shut it down, but participant says, look, that should never have even happened in the first instance. It constitutes a violation of the standard of prudence under ERISA. That participant could request that the court order some type of equitable remedy, some type of change to the plan, something like that.
Okay. Right. So we've covered the first two sections, which is the scare us all more than perhaps we're ready with all the issues that are coming up. And we focus on the third one, which a little bit more positive is, well, what can we do about it? What should companies be doing? So Cristin, you work with ERISA plans on fiduciary compliance. What would you say generally plan sponsors should do first to begin dealing with cybersecurity issues?
Well, I think one of the first things is the committee needs to educate themselves on it. Rick and I have actually met with a few committees and specifically as part of fiduciary training, or in one instance, the whole purpose was to educate them on the cybersecurity as to, again, what is their responsibility in all this? Why is it important? What role do they play? And so it's a lot of information. I mean, as Rick pointed out, there's a lot of technical parts to it that some committees members may or may not understand. But in terms of just understanding the whole sense of what the risk is, what their duty is, kind of once you have that framework, I think then the next step is for the committee to come up with a compliance plan. How are they going to address all this? I guess you could compare it to some, maybe like an investment policy statement, where it's more of a guideline rather than a to-do list. And also because this is ever evolving, the cybersecurity, this is something that's maybe more of a working document at first in terms of how they're going to address all this. And also look at their committee members. Maybe there's somebody who has an expertise in the cybersecurity. Maybe they want to have a new committee member added who kind of could help out on the, regular meetings. But this is something where I think has to be part of the agenda going forward. I think I know you work with a lot of committees or attend most of the meetings, Chuck, and how they have I think you help set the agenda for the year.
Mhm.
This is something where it should probably be, reviewed at least once a year, maybe more in the beginning, twice, because, things are evolving. But kind of, come up with a plan as how it's going to be addressed. And again, this is something where if the DOL does come in and, seek information, that will be very helpful to your process that you've put this in place.
Mhm. Great. So we have listed here the compliance plan that you referenced there, Cristin, and then several internal as well as external steps that you should be taking. So Rick, do you want to speak to that? What companies should be doing to deal with their, internally cybersecurity issues as it relates to retirement plans?
Sure. And Kristin's point is a very important one, and that's drafting a written set of policies and procedures. And this is something that the DOL is actually requesting to see in audits, requests that they've been issuing over the past couple of months. So with respect to the internal cybersecurity, so this is at the company itself, the plan sponsor. First of all, plans want to follow the terms of the written policies to the extent they can. If there's some compelling reason why you don't comply with written policies, you can sort of deal with that. But once you have drafted written cybersecurity policies, you want to follow them generally. The service provider tips that the DOL issued that provide that very technical sort of guidance, that can also serve as a roadmap for plans to assess company-side internal cybersecurity measures. So plans need to secure their internal information about participants, identifying information, access to accounts that have authority at the plan to make changes to the plan, to make changes to plan assets, things like that, that the plan side needs to make sure that those accounts are secured. And practically speaking, though, a lot of these cybersecurity measures are assessed at highest level of IT in a company or even management at a company. And what we are seeing are some discussions between plan committees who may have no authority whatsoever. They have authority over the plan, but when it comes to then what is the company doing to secure information, they may have no authority at all with respect to those issues. There's this dynamic between what plan members may say and what the company side people may say, and they have to make sure they're on the same page. And sometimes we will become involved and assist the plan in communicating to the company the need to assess some of these issues as the company isn't already addressing these as a matter of business practice. So that's the general outline for assessing the internal cybersecurity risks company side.
Great. Thank you very much. And then I see number 6 is something that is near and dear to our heart at Finspire on documenting the process, which we describe ourselves as document hawks of every decision that you make. And whether it's Chris Redford's investment policy statement, but this certainly falls into that as well. So document that there is a process in place and that you're following it, particularly with committees where people come on and off the committees. And making sure there is a consistency there. That last one, 7, is a really interesting one, insurance and indemnification. And at the end of last week, I spoke to somebody's insurance broker working with corporations, P&C and D&O insurance, and said in the last 6 months, he's never had more requests asking about cybersecurity insurance and what does it cover and what it doesn't cover. And so can you talk a little bit about that, Rick, on insurance and indemnification?
Yeah, sure. So actually, when I was a law student, I was a summer associate at a firm and I got started working on insurance coverage. And this was right around Y2K. And cyber liability policies were first being issued, first becoming available in the market. And I spent the first half of my career as an insurance coverage lawyer and became very familiar with cyber policies. They kind of fell sort of out of fashion for a while. But as you said, now that there's just constant talk about cybersecurity because of the recent, very public hacks and ransomware with companies, and also because of governmental requirements. You see this at not just the DOL, but DOJ and other governmental agencies are assessing cybersecurity issues. So insurance, there are two types of insurance generally that people need to be aware of. One is like your home owner's policy. It's not really meant for lawsuits against you. It's meant for, hail, flood, that type of thing, damage to your property internally. There's a type of cybersecurity policy that protects data from similar losses, and they can be, it can be external losses, could be hacking, could be damage to physical property. Something like a server or a drive with important information gets physically destroyed, or even just damaged somehow, corrupted somehow. There are cyber liability policies or cyber policies that will protect from those types of losses, including restoring the data. In some instances, they include, public relations coverage if you have to deal with the very public fallout from some of these incidents. So that's this first party loss type of policy. The second is the type of policy that protects against the lawsuits. So the one that Cristin talked about earlier, the situation where a participant's identity is stolen and that participant then sues the plan under ERISA for breach of an ERISA fiduciary duty. Most of the fiduciary liability policy, so the package policy that companies maintain with directors and officers, employment practices, fiduciary liability insurance, those will cover or have historically. I shouldn't say they will, because I think we're going to see some endorsements issued to limit this. But if there's an ERISA breach of fiduciary duty and the underlying duty happens to be a cybersecurity one, that still should be covered under most fiduciary liability policies. So, but you have to check. And you also have to check for other types of lawsuits, non-ERISA lawsuits. So against the company, if there's some type of data loss and shareholders bring a suit, these are cybersecurity issues as well that could be addressed with insurance. Then you have the indemnification arrangement. Now, we often hear people say, we're protected, we have indemnification, from a service provider internally. And, Cristin and I were just talking about this again, we talk about it all the time, but we sort of shrug our shoulders and say, well, that doesn't mean anything to us unless we see the express language of the indemnification clause. Indemnification is extremely nuanced. I published a piece in the Journal of Employee Ownership recently, an academic journal, on the history of indemnification under ERISA, and I got really entrenched in indemnification principles and distinctions and nuances under state law and under ERISA, what the contours are of an indemnification provision. And it can be very complicated stuff, but the bottom line is, if you have fiduciaries of the plan, individual members or a committee, there should be, in my opinion, broad indemnification protection from the company to those members in the event of some type of action alleging that they breached a duty. You also have indemnification that's negotiated between or among private parties. So this is just a matter of contract, where private parties will typically take the position that if one party is sued because of the conduct of the other party has to indemnify. You also see indemnification that just says, regardless of whose fault it is with respect to a certain category of risk, one party is going to assume the liability if either party is sued with respect to that category of risk. But you want to you got to figure that out upfront in the agreement. You want to assess who's going to be responsible for what, when is indemnification going to apply, what are the carve-outs and carve-backs going to be. You want to make sure that it complies with any state law requirements or federal law, ERISA or other law requirements. And that's an extremely, extremely important way, in addition to insurance, of providing protection. And this sort of gets to just one general broader point I'll make, is that we're very aware as litigators of the practical concerns in lawsuits. So we may all, you can get everybody on this call and poll them and give them a hypothetical, and we all could agree that, yeah, that's really not the plan sponsor's fault in that instance. The practical matter is that's never going to prevent a lawsuit from being filed. It may not prevent a judge from actually issuing an adverse ruling. If you have a participant that lost a significant amount of money and a court is trying to decide on whose shoulders that should fall, you have to take into consideration the dynamics there. And if as part of a cybersecurity policy, a risk mitigation practice, fiduciary service providers, people need to be on top of their insurance and their indemnification because, specifically because of these issues.
Great. Those are really great points. And it is, again, very nuanced. And we see, that's why we rely on like Cristin and Rick for our clients to decipher these things with policies and with indemnification. So wrapping up our discussion today, in summary, cybersecurity is a shared responsibility. It's not just on you as the employer. It's between the plan sponsor, the service providers, and the plan participants. And that's going to DOL gave specific guidance on those three areas. It is your part of the fiduciary's obligation to evaluate your providers, and that includes cybersecurity. And it falls into the recent guidance into those three areas: hiring and monitoring service providers, service provider best practices, and tips for plan participants. Evaluate your cybersecurity strategies and hire experts for assistance with this. So closing, we hope you found our discussion today to be helpful, insightful and helpful. I'd like to very much thank Cristin Obsitnik and Rick Pearl from Faegre Biddle for doing a terrific explanation on the issues in cybersecurity and giving you hopefully some good tips for that. We've recorded this session and it'll be soon be available on the Finspire YouTube page, which you can access directly through our website, which is www.finspireme.com, along with recordings of prior sessions. Please feel free to reach out directly to Cristin and Rick with questions that didn't get answered during our discussion or any follow-up assistance that you might need. Feel free to reach out to myself and our team here at Finspire with questions on overall plan governance and assistance with managing your corporate retirement plans. Thank you all for attending today, and I hope everybody enjoys the rest of their day. Thank you.
Thank you, Chuck. Thank you, everybody at Finspire.
Thank you.